Welcome to Law 2021 online. Wills and Probate Shape the Debate, sponsored by Inheritance Data and me, Bruce Kane. In this live session, you can put your questions to Leslie and John and interact as information is being delivered. Today's live question and answer is due to last 1 hour, and we will cover your pre-submitted and live questions. To the right-hand side, there's a chat function. All questions are submitted in private, so please ask away. If you're watching a replay, the live chat function is disabled, but you may contact the solicitors group for further information. Recording of today's live session will be sent out by email within the next few days, so please keep an eye out for this. I'm Bruce Kane from Inheritance Data, Financial Asset Searching and Estate Administration. I'm the founder of Inheritance Data and have advised on unclaimed assets and their repatriation for many years. Inheritance Data is the UK's leading financial asset search platform and is devised to explore financial institutions' records to establish the deceased's full financial history and expose all assets which are due to the estate during its administration. Acting on behalf of probate professionals, Inheritance Data contacts over 200 financial institutions, the DWP, Pension Tracing Service, and other databases via our online portal using only one query. Responses are updated live in the online report as they are received. The service is used by solicitors across the UK as part of vital due diligence and is conducted as soon as the estate administration is started. It is routinely used by law firms on a blanket policy basis on all probates. Professor Leslie King is a leading professional author and lecturer in wills, trusts and probate. Leslie is a former member of the Law Society's Wills and Equity Committee and the Probate and Estates Committee of STEP, and an honorary member of the Association of Contentious Trusts and Probate Specialists. She is also a professional development consultant at the University of Law and writes and lectures extensively on private client matters. As part of Law 2021 online, Leslie's sessions include private client update, property issues for private client practitioners. John Thurston is a non-practicing solicitor. He is particularly interested in the law relating to wills, trusts, taxation, powers of attorney, and elderly clients. He is the author of various books and contributes to loose leaf works. He has practiced and is now a trainer. John's sessions for Law 2021 include elderly clients and care home fees, lasting powers of attorney. So, to kick off, we will start addressing some of these pre-submitted questions we have been receiving from you. First question for you, John. Do you have any idea what proposal the government will produce about care home fees?
I don't think anyone has. No, I've lost track of how many times government says they're going to produce some proposals, but they never seem to be forthcoming. Well, I say they never seem to be forthcoming. I mean, the coalition was going to implement something called the Dilma Proposals, which really would have meant most people would have been paying in full care home fees in any event, actually. But they dropped those or postponed those. And of course, the coalition lost it. I think Mrs. May came up with this idea of everyone would be left with £100,000, didn't they? And that sort of went down rather like a lead balloon, actually. So she very quickly abandoned that. But I think there has been some suggestion that the current government will produce some sort of green paper. But I think they might have been a bit preoccupied with other matters before they get around to this, actually. So I suspect that nothing very much is going to happen, actually. Partly because it's a bit of a hot political potato. I mean, any proposal that they produce that means that people are going to have to pay more money for their care or care home fees, it's not going to be that popular, is it, actually? So I suspect they might just leave things as they are. Or in effect, most people do have to pay for their care and care home fees. But I might be wrong. You never know. But if they think there's votes in producing some proposal, being cynical, yep, you might suddenly get a proposal about it, actually.
I can't see anything happening anytime soon. I mean, I think that's a bit of a trope, for so many things, because, you can't really blame them, can you? They have got other things on their mind.
True, very true.
Yes. So
Well,
that's the answer to that. I think we both agreed, aren't we, Leslie? Yes. Nothing probably will happen. We'll just continue with the existing rules. Up in a care home, the whole value of the house should be disregarded. It determines the contribution to care home fees. So just by putting it into joint names, well, even if it's the name of one, and if the other spouse or partner or cohabitee finishes up in a care home, the whole value of the house should be disregarded. They determine the contribution to care home fees. The only perhaps advantage in putting it into joint names is if they are tenants in common, they can make wills giving each other a life interest in their respective shares in the house. And shall we say husband or wife have done this, giving each other a life interest in their half share in the house. The husband goes and dies, well, his half share goes into the trust. But if the wife then finishes up in the care home, local authority, it's very difficult for them to get at the half share that's in the trust, actually. But of course, they've still got the wife's assets. The wife has still got a half stake in the family home, which they can take to pay care home fees. But certainly in the past, when this idea has been done, what's happened is it's usually the adult children who are the executors and trustees of this lot. They pay hardball and say, we don't want to sell the parental home. So you then have issues about how you value a half stake in an unsold house. And some local authorities will say it's 50% of the full market value, but it clearly isn't, because you could find anyone to buy a wise 50% stake. They're not going to give you 50% of the full market value. They want a bit of discount off. Certainly does have some value.
The thing that I've heard occasionally people worrying about is you've got dad died, left his half share into the trust. Mum then goes into care. Adult children say, oh, we don't want to sell, and anyway, the half share in the house would be worth almost nothing. And then people are worried that the local authority will then say, well, if it's really worth almost nothing, we'll buy it for almost nothing.
I know. I've never come across any local authority doing that. But yes.
I haven't either, but I know that people do worry about it.
Yeah. So I think, just by putting it into joint names isn't really going to, well, as I say, it's protected in any event. If you've still got one finished up in a care home and you've still got a spouse, still partner, cohabitee living in the house, it's still protected in effect.
Well, it looks like another question for you, John. It seems to be going all your way at the moment.
That's right.
Is it in order for a client who appears to be fit and healthy to make a large gift of money to children to avoid care home fees?
Yeah, well, this is a difficult one. This is actually because there is statutory guidance about this, actually. And that statutory guidance does make it plain that a local authority shouldn't do anything about it. If when they give away the large chunk of money, they're fit and healthy, no reason to suspect that they're going to go into a care home, actually. But having said that, I think it's fair to say local authorities are getting more aggressive about this, actually. So they might very well challenge it, actually. And of course, I think if you're going to do it, then you perhaps need a medical report. You are fit and healthy, not likely to finish up in a care home or anything like that. But certainly if someone does give away large chunks of money and perhaps suddenly has a stroke or something like that and finishes up in a care home, the local authority may look very carefully at it, actually, aren't they? That will disable them and things like that, actually. So, I mean, strokes can strike just like that, can't they? So I think it's difficult if they do it. But yeah, there's always the risk the local authority will challenge it at the end of the day.
I think having a medical report is a good idea. I think also if you can document why you're making the gift.
That's another reason.
I mean, it may seem obvious. I'm doing it to help my children, but it's worth writing it down.
Yeah.
And you can sometimes find it quite helpful if you want to make another gift later on. And the reason you've made two gifts to your previous two children as they reach 25. maybe your health's not quite as good now, but you want to make the same gift to your youngest child. So just any degree of documentation is helpful.
There was a case I think came up a year or two ago before the local government ombudsman.
That's the one I'm thinking of.
I think which doesn't they can't really sort of overrule the local authority's decision, but they can say they've not gone through the proper procedure, which in some ways is basically overruling the local authority's decision. I think the case you're talking about, I think parents had given chunks of money to 3 children, hadn't they? But
they had, and they wanted to even up on the 4th. And they had got the intention that dad was going to stay at home forever, but he just deteriorated very quickly and went into the home.
Yeah.
Right, I think this is a general one, but I'm probably more to me. Can an executor charge further fees if more assets are revealed years after the estate has been distributed? It's one which started me on this route is because the financial institutions from time to time do cleansing of their lists, and all of a sudden find £10,000 in a savings account, an ISA, a pension fund that nobody had seen. And the professional executor then says, oh, well, I can charge again, which I find morally, really should you. So that's fine if there is the money in the in that estate. But what happens if it's £500? Can they charge? Either of you got a view on it?
I'd say it depends on what the charging clause says, because you start from the position that you can't charge unless you are authorized to charge, and you have to be charging reasonably. So I would look and see, first of all, what the charging clause says, if there is one, and then I would consider what is reasonable.
I think it all depends on the terms of your contract or retainer, doesn't it, with the executors or administrators, actually.
Well, what are we talking about?
We're talking about the executor charging for a second time. So they've been paid to distribute the estate, then further funds are found.
Yeah.
It then comes back to them. They hadn't found all the funds. So they then say, okay, we'll open the file, which means if it's 5, 6, 7 years, they have to pull it out of archive, trace the beneficiaries, and redistribute. Now, if they'd done the job correctly in the first place and done a financial asset search, they wouldn't have this problem.
7 years ago. I can see that as we get more used to making these searches, you might be more critical of the person who didn't find.
Well, the executors, or whoever's dealing with it, has got to do it for nothing in effect, actually. But if they've sort of agreed to, well, they're going to be paid by the screen suddenly gone blank.
I can still hear you, John.
Can you? All right. Well, I'll carry on then.
Yeah,
okay.
I think you probably
can hear
can.
You as well. Then I think if they've agreed to a fee based on how much time it's going to take, then I think possibly yes, they could charge then actually. But if they've agreed, I think one firm I work for, it did sort of say they charge by the hour, but it also quoted a maximum. So if you've done something like that, it does seem to me that you can't do much about it. Let's see if I can. I'll turn video on again. Yes.
Yes, we've been rebooted. So here we go.
Wasn't there a question about the lasting power of attorney as well, tagged on to the end of that question? When should you register it?
There was back on question 2.
Yeah.
Yes. Yeah.
When should you register a lasting power of attorney?
When should you register a lasting power of attorney? Well, if it's a health and welfare one, as soon as it's granted, just in case the donor is suddenly stricken with some awful illness and can't make decisions about their medical treatment. And I should say a health and welfare one, it's only effective if the donor lacks mental capacity. So, yes, but having said that, I mean, people sometimes are suddenly stricken or with illnesses and lose capacity or have an accident or something like that. So I've always had no doubt. So if you're going to do a health and welfare one, it should be registered in effect as soon as it's granted. The property and affairs ones, that's a bit more difficult actually, because I think on the whole, people do them in their 50s or 60s. The chances are they'll never be needed, but they may never lose mental capacity or anything like that at all actually. From my experience of clients with lasting powers of attorney, I'd always give them the choice as to whether it was registered straight away or whether they waited until they lost capacity in effect. Most want it registered straight away. And
that's because they think they'll forget or lose it.
Yes.
Which is much the same way that I felt when I did mine. I thought best register it straight away. But
I think sometimes there's also been pressure perhaps from adult children to get it done as well. So I think once it's been registered, they can go back to the adult children and say, oh, it's all done and dusted. We can forget about it now, actually. You get off our backs over it, actually. I think there's sometimes that element there.
There might, of course, be an express provision in the lasting power saying that it is not to be registered until a medical practitioner has said that you lack capacity, in which case, of course, you can't register it. I mean, there's quite a lot to be said for getting it registered and gradually the attorneys starting to help with the general running of the financial affairs, although can be a double-edged sword, as we all know, with as soon as people start getting their fingers on the money, they tend to find all sorts of things that they're sure mum would want to do with that money.
Okay, well, moving on, here's one for you, Leslie. Am I right in thinking that Hmrc has extended the registration date for non-taxable trusts?
Yes, yes, you are absolutely right. They have twice. So just a little bit of background, as I expect everybody knows, we are going to have to register non-taxable trusts. Under the 4th Money Laundering Directive, you only had to register a trust if it had a tax liability. And lots of trusts exist without having tax liabilities. So if it's a trust of a house that's held for mum for life and mum's living in it, there is no tax liability on that house until mum dies, and then the trust comes to an end. So under the 4th directive, we didn't have to register those trusts at all. Under the 5th directive, we are going to have to register all non-excluded trusts, irrespective of whether or not they have a tax liability. And the government said, oh, well, gosh, that's a lot of trusts out there that are going to have to be registered. So we'll have a long transitional period. And originally they said, you will have to register by 10th of March 2022. But they said, you can't register at the moment, this was last year, because we've got to amend the register to make it possible for non-taxable trusts to register, because you'll have to answer different questions. And oh, what a surprise, with Hmrc's record on matters technological. They've had some problems with updating the trust register. So they announced about 6 weeks ago that they were ditching the 22nd of March deadline. And whenever they finished updating the register, which they estimated would be summer this year, the deadline would be 12 months after whenever they announced that they had finished adjusting the register. And then I think it was about 10 days ago, they announced, actually, we're not going to have finished updating it by summer this year, more likely autumn this year, but it'll still be a year after whenever we make the announcement. So I don't think anybody should be, getting in a twist about registering their trust details, because you can't do it at the moment, and we have no date for when the deadline's going to finish.
I agree. Those are wonderful things, aren't they? It was a program properly. That's the trouble.
Well, it sort of follows on from that. The trusts holding only a life interest of the matrimonial home have to register.
Yes, I mean, that was the example I just gave. It no longer matters whether you have a tax liability or not. You have to register unless you're excluded. And there is it's a reasonably extensive list of exclusions, but they're all trusts which are very highly regulated, like trusts for charities, or very unlikely to ever be used for money laundering or terrorist financing purposes. So trusts of death benefits and pension benefits are excluded, got rid of within 2 years of the death. And having that sort of 2-year transition or breathing space means that actually you may never have to register a will trust. But in answer to the question, yes, you do have to register a trust with a life interest in a property.
Okay, well, we just had a nice live one come in, which is where the will of the deceased give a right to their sister to live in a house indefinitely. If the house is assented / transferred out of the estate to the sister and others in agreed shares, would this supersede / circumvent the interest in possession that would otherwise cause future problems with substantial IHT liability when the sister dies? Not very good English, but
no, I'm just trying to work out the question.
Talking about a will, are you, where someone's just given the right to live in a house? Yes, and the house goes to other beneficiaries. So ultimately,
yeah, I'm not. Where the will of the deceased give a right to their sister. Where the will of the deceased gives a right to their sister to live in the house indefinitely, IPDI, if the house is assented / transferred out of the estate to the sister and others in agreed shares, would this supersede, circumvent the interest in possession that would otherwise cause future problems with substantial IHT liability when the sister dies?
Well, you can get rid of the immediate post-death interest if all the parties who have an interest in the house are of full age and capacity and between them entitled to the whole beneficial interest. So if you can get the sister who has the right of occupation and the beneficiaries who are entitled to the remainder interests, if they can get together and vary the way in which the will is left, then you can rejig the disposition of the estate as you see fit. And if each of them are going to have a quarter interest in the house, each of them will own a quarter of the house for IHT purposes. Now, you create other non-IHT problems when you have co-ownership. It may also be the case that the trustees have overriding powers which allow them to terminate the sister's life interest and appoint interests in the house. If it's being done like that, where the trustees are acting to terminate the sister's life interest and divvy up the capital amongst all of the beneficiaries, then she will be treated as making a transfer of the value of the house. And that could itself create an IHT problem down the line if she dies in 7 years' time, because that deemed, or within 7 years, because that deemed transfer of the house is going to eat into her nil rate band. So yes, you can terminate the immediate post-death interest in various ways, but it doesn't necessarily mean that you will bypass all your
issues of children, grandchildren. So
charity, if you're unlucky.
Charity. So it's possible that you can't get them to agree without going along to the Chancery Division, which is probably not worth it if it's a relatively small house or anything like that. I've got to know, Leslie, an expert on this, deeds of variation.
Well, yeah, that's what I was saying. If you can get all of your beneficiaries are of full age and capacity, you know, Saunders and Vautier, they can vary the way in which the property has been left. But you would then, as I understand it from the question, end up with, say, 4 people owning a bit of the house, and that brings its own problems. The other way in which you can finish an immediate post-death interest is if your trustees have been given overriding powers so that they can terminate it and appoint the capital as they see fit. The difficulty with that one, by comparison with the post-death variation, is that because the sister has got an immediate post-death interest, when you finish it, she will be treated as making a transfer of value of the value of the house. And that will eat up her nil rate band if she dies within 7 years of that deemed transfer. So there's 2 ways of doing it: post-death variation if you're within the 2 years, and exercise of the overriding powers if you've got any.
We finish up. If the trust comes to an end, you're going to get a deemed disposal at market value for capital gains tax purposes, aren't you? I suppose it might be covered by main residence exemption. Possibly.
Yes, it would be. Section 225, I think it is, which says if you've got a beneficiary occupying.
Yeah.
Well, that sort of leads on to the next one, which is if you own as tenants in common a property in unequal shares, is this trust to be registered?
Oh, now that's a very good question. Now, let me just try and remember. So you've got co-ownership. I think it's all right. I'm just trying to remember the exact wording in the schedule. I think when it talks, the rule is that if you've got an express trust, it has to be registered unless it's excluded. One of the categories of excluded trust is where you have the statutory trust that applies on co-ownership, because obviously that's not an express trust. So if you've got 2 people buying, one puts in 2/3 and the other puts in 1/3, you've got to have the statutory trust. Normally, you don't have to register a statutory trust where you simply own equally. The thing I'm struggling with remembering is if you varied the beneficial interests, because then it comes close to being an express trust. So I think what I'm saying is I can't remember with 100% accuracy. Normally, a co-ownership trust, you don't have to register. Where you're owning unequally, I need to check the schedule, but I have a feeling that you probably do have to register it where it's unequal. Do you know, John? Can you remember?
No, I'm not. No, but I think you're right. Actually, I wouldn't like to know if they vary it unequally. I mean, it seems to me the idea behind this is that where trustees are holding assets for beneficiaries that aren't named, isn't it? Wherever you want to know just who is the beneficiary. Yes. If they're co-owners, even if they own it, if they co-own as the legal estate, even if they own it and in equal shares, then we've not got different beneficiaries, have you? In effect, they're one of the same people. So I think logically it should not be registrable, but like you, I'm not 100% certain, and you never quite know.
Well, it's because the wording is that express trusts have to be registered, non-express trusts don't. But where you've got unequal beneficial interests, I think that is actually as a result of a variation, of the beneficial interests. So I think probably 75% degree accuracy on this one, but probably you do have to register if your interests are unequal. You don't if they're equal.
Yeah. But you're still not hidden though, because you're still probably going to have the co-owners as the trustees, aren't you? Actually,
yes, you are.
Yeah,
you are.
Yeah.
But the extent of the beneficial interests, people would be interested in on the register.
Yeah.
Okay, then moving on to the next one, which is how can an executor ensure that they have located all the estate's assets in order for them to be able to
One for
prove that
you.
they have
Go to you.
completed due diligence? Well, they conduct a financial asset search. There's 200 billion pounds out there just unclaimed. It's getting bigger every year. You only have to look at the Reclaim Fund Limited. That's sitting at 1.2 billion, increasing 100 million a year. NSNI, that's now 3.4 billion pounds, and it's gone up $1 billion in 4 years. If people don't search, and these are just, you can go onto their accounts and see it.
Yeah.
And so when the beneficiaries or the executor asks the beneficiaries, do they know where everything is? They don't. Otherwise, if they did, these figures wouldn't be getting bigger. So my recommendation, is to do a financial asset search, and get a warranty on it, so that if something is missed, when it is opened up in 5 years' time, there's no charges. It's the company that did the financial asset search's problem to pay those costs. So you just have to search. And it's not just the banks, it's the pension funds, it's the asset managers, life insurance. They're all huge figures. So that's my summation, and we're the market leaders at it, and I've been doing it for 12 years. So.
We're not disagreeing with you.
Moving on, we've got clients usually want to give the house to children and usually say that to avoid care home fees, what advice should we give them?
Well, this is one for me, actually, isn't it? Really, actually. This is the problem that most practitioners are faced with, actually. Parents come in saying, okay, we're concerned about care home fees, want to give the house to the children. Well, I think the first thing I always try to find out is whether it's really the client sitting in front of you concerned about it, or the adult children, because quite often you find it's the adult children who are the ones who had to go at the parents over it, actually, and say, right, well, if you finish up in a care home, our inheritance will disappear, in effect. Go and give the house to us, actually. So I think that's the first thing. And some children, of course, can be really ruthless over this. They can put a lot of pressure on parents to do it, actually. And actually, I do remember a delegate telling me once that she'd come across a case where, clients had come in saying, I want to give the house to the kids. And she eventually found, after a lot of digging, these adult children had gone in and seen the parents and said, unless you give us the house, we won't let you see the grandchildren anymore. I know, which is pretty ruthless, isn't it, really, actually? So that's the first thing. There's obviously this risk of the deprivation of capital rules if someone's deliberately deprived themselves of the assets with the intention of getting help with the payment of care home fees. The local authority could just assess them as still having that capital. So if they really do want to do it, it is very dangerous for them to give the house to the children absolutely, because you never quite know what the children are going to get up to. And of course, the big danger is if a child goes bankrupt. It could be quite difficult stopping a trustee in bankruptcy, enforcing a sale, getting divorced. That will be taken into account in the divorce proceedings. Predeceasing parents, you don't know who they're going to leave the house to. But having said that, it is relatively easy to protect the rights of the parents to stay in the house for the rest of their lives by some sort of lease or license or declaration of trust or something like that, actually. So you can quite often get around that particular problem. But there's also other issues as well, because if they do give the house to the children and they want to move, they've got to get the children to agree. And of course, children sometimes have very different ideas to what is in parents' best interest as to what the children want to do, actually. But also, of course, and these are being fairly heavily marketed at the moment, that these equity release mortgages, in effect, actually. And of course, I think quite a lot of people perhaps don't have much in the way of pensions, and they may have to release some capital from the house just to keep up their standard of living, in effect. And of course, if they're giving it to the children, I don't know, I suppose it may still be possible to raise some money on it, but I think it gets a bit more difficult actually, but still, there they are. Well, you're starting gifts from by the children to the parents, aren't you, and things like that actually. So I've always tried to dissuade clients from giving the house to the children in effect actually, because I think you need to retain the ability to deal with your own home freely right up until the time that they die actually. And certainly that's my attitude. I've got 3 children. I'd never give my house to my 3 children or anything like that. But still, anyway, I mean, having said that, I mean, if they really are determined, so they really do want to give the house to the children, and there's other reasons why they might want to give the house to the children. I think some clients are a bit worried about being taken advantage of by pushy salesmen and things like that. So that's one reason. Another reason, particularly when the government was threatening to increase the probate fees up to some astronomical level to avoid probate fees, possibly to avoid the need for a grant of probate or a grant of less administration because they may not have much capital beyond the house. So, yeah, there are perhaps other sort of reasons. And also, of course, that if they lose mental capacity, well, you have to get a deputy appointed if you haven't done a power of attorney to deal with it, actually. So there are other reasons, actually. But this is the problem an awful lot of practitioners are faced with, that clients come in 60s, 70s, or even 80s and say they want to give the house to the children, in effect, actually. An awful lot of clients, I think if you talk to them about the dangers and the disadvantages, they'll probably change their minds, actually. But if they really do want to give the house to the children, well, if we go back to the statutory guidance, as long as there's no suggestion they're going to finish up in a care home, in effect, then the local authority shouldn't be doing anything about it. Can't be foreseen that they're going to finish up in a care home. Then local authority is told they shouldn't really do anything about it, actually. So if they really are desperate to do it, yes, I think as long as you've got the medical certificate, they're fit and healthy, not likely to finish up in the care home, maybe it's all right. I mean, another motive sometimes is, of course, love and affection for grandchildren, in effect. I do remember coming across a case like that where this man wanted to give his house to his granddaughter. He'd only got one granddaughter who had certain health issues, to make sure she got somewhere to live, actually. But he wasn't going to run himself homeless, and he was going to sort of move into an annex at the back of his daughter's house. Well, you know, something like that, perhaps it is genuine then, isn't it? Actually, a genuine reason for doing it, actually. So,
I mean, I think I'd just add to that. John, you mentioned protecting the right of occupation of the parents. I mean, there are an enormous number of asset protection trusts out there which are being very heavily marketed, and a lot of money is, you know, being charged for them. They are vulnerable to local authorities asking, why did you give your house to a trust, for all the reasons that you said. But also a lot of them are very complicated. And I think I can truthfully say that I have yet to see one which I thought actually worked, you know, because it's quite difficult to draw. I mean, it's not that difficult, but a lot of the trusts actually haven't been that well drafted. You know, I'm lying. I have seen a couple which I thought were well drafted and did work, but I've seen an awful lot that don't. And I've also seen a lot of cases where the people who signed up for these trusts and paid a lot of money for them actually didn't really understand what they were getting, or why they were doing it even.
And also, I think these trusts, and you're quite right, they're being fairly heavily marketed by some companies, aren't they? And
you can see why, because so many people, it's what they want. They want to preserve the house for their children, and you know, they don't want the local authority to take it, and they want to have security of occupation.
But the local authority have got quite a powerful weapon now under Section 70 of the Care Act, that if someone's given away an asset with the intention, in effect, of avoiding care home fees or something, they can just bill the donees with liability for the care home fees. I think if a local authority does come across someone that's put one of the houses into an asset discretionary, one of these asset protection trusts, will commit to the children, then they might very well just bill the donees with liability of the care home fees and say, you fight us on it. So that's quite a powerful weapon. And they've also got Section 123 of the Insolvency Act. And I should say with Section 70, there's no time limit. So in theory, a local authority could go back, 10, 15 odd years, but they would have difficulty proving the motive, I think. Then.
Yeah, you've still got to have the deliberate deprivation.
Yeah, and the motive to avoid sort of care home fees, in effect. But there's also Section 123 of the Insolvency Act, which
has been used by Derbyshire County Council.
Yeah, which has no time limit, where a local authority. Insolvency Act is really concerned with bankruptcy, but this is not dependent on anyone being made bankrupt. But I suppose the official receiver can apply to set aside gifts made donkeys years ago. Again, if they've been done with the intention of sort of prejudicing the interest of creditors.
That's it.
So that's another powerful weapon if they really want to deploy it. So,
right. Oh, okay, then the next one. If someone has disclaimed an entitlement, thinking that the property will go to one person, but in fact it goes to another, what, if anything, can be done to solve the problem? Whoa.
Okay, so I give up my entitlement under a will, thinking that the property is then going to go to, I don't know, my daughter. But in fact, I've got grandchildren from a dead son, and it's going to be divided up between the grandchildren and the sister and the daughter. So it's gone to the wrong people. Well, there's nothing I can do because I've given up my entitlement, and the property has passed to whoever it passes to. If they are feeling amenable and are adults and have capacity, provided we're within 2 years of death, they could either disclaim themselves, but then where's it going to go when they disclaim? Or they could do more likely a post-death variation, because there's nothing to stop you having disclaimer followed by disclaimer or disclaimer followed by variation. The only thing that you can't have is a variation followed by a variation. So if I've disclaimed and it's gone to the wrong person, if the wrong person is feeling amenable, they can do a post-death variation to give it to whoever I wanted it to go to. If they're not feeling amenable, as I said, there's very little that I can do, except I suppose if it was worth it, I might be able to apply to court for rescission of my effectively gift on the basis of mistake. But, whether or not it would be worth it, B, whether or not you could convince the court that you'd made the right sort of mistake, which is one of the problems with rescission. It's not guaranteed that you would get it set aside. But those are the only things that I can think of.
Yeah, I suppose the only other issue is that if professionals been involved in it and clients want to disclaim in favour of someone else and they've made a mistake and that person is not going to get it under a disclaimer, then of course they'll have a right to negligence against the solicitor who'd done that, actually.
Yes, you would. But if you'd simply messed it up yourself.
Oh, you messed it up yourself.
Yeah.
You've had it. But if someone's made a mistake, it's honest, but still. Yeah.
Okay. Is there any risk of a penalty if an IHT relief is claimed for agricultural or business property which Hmrc refuses?
Yes.
Yes,
but it depends on the circumstances. States the amount of tax which is due as a result of carelessness or as a result of a deliberate action. So if you're the personal representatives and you put in an IHT account which says that you are entitled to either business property relief or agricultural property relief, in circumstances where it is blindingly obvious that you are not, then the revenue is going to say that you're squarely within a penalty. Inaccurate account, understating the IHT, and you've done it either carelessly or deliberately. Two I've got feedback. I don't know if anybody else has got feedback, but there's nothing I can do about it if you have. Two sort of short anecdotes about wrongly claiming reliefs. One was somebody who emailed me to say that they had merged with another firm, and somebody in the other firm had claimed agricultural property relief on ground fields grazed by ponies. And this is actually in the manual, as you know, you do not get agricultural property relief if you've got fields which are being grazed by ponies. You know, it doesn't count as agriculture. And so the revenue had imposed a penalty. And the question was it worth appealing the penalty or not? Well, answer, not worth appealing the penalty because it was a bang to rights job. On the other hand, the revenue has got power to suspend a penalty if they can impose suitable conditions. And the firm did go back and they did say to the revenue, would you consider suspending the penalty here? And the revenue said, well, if the individual involved goes on some courses on agricultural and business property relief, we'll suspend the penalty, which I thought was a very good result, actually. Yeah. So there was that one. And then another one where if you get business property relief, you don't get business property relief on accepted assets. So accepted assets are assets which aren't required for the purposes of the business in the future and which haven't been used in the business for the last 2 years. And I've come across two situations. In the first situation, the professional advisors had said, there's clearly a lot of cash in this business, which is not required for the business. It's just been building up. So this is clearly accepted assets. So we're going to claim business property relief on the value of the business. We'll include all of the cash in our claim for business property relief, even though we know that some of it was surplus to requirements. But we know that the revenue will knock us back a bit, but it's a good negotiating position. We'll start by saying we're entitled to business property relief on the whole lot. Then we'll argue a bit and then we'll agree a figure on the cash. And the revenue really played hardball. And they said, look, you knew that you were not entitled to business property relief on all of this cash. And yet you put in a claim for business property relief on all of this cash. You have deliberately understated the amount of IHT that's due. And the firm involved had a long time arguing with the revenue to get it reduced to a smaller penalty on the basis of carelessness. So it really is quite dangerous claiming a relief where you think, I'm almost certainly not going to get this, but I'll give it a go. Actually, I'm just going to say this and then I'll stop. I had somebody in an audience who said to me that they had said categorically to their clients who were the personal representatives, do not claim agricultural property relief on this land. It was another one grazed by ponies. And the PRs insisted, and they got a penalty of something like £70,000 or £80,000. And the professional advisor involved said, actually, I was really pleased because I had told them categorically, do not do this. And they had persisted. So really dangerous thing to do.
Yeah, the only issue I think is there's quite a lot of sort of grey areas with business property relief. Which
is at the IHT 400. And you should have said that not all of this cash is required for business purposes.
But in effect, business property relief is limited to trading businesses, and it can sometimes be very difficult to know.
Oh, absolutely.
Whether it's a trading business or perhaps someone's.
But I think the thing is, if it's a grey area, that's one thing. Yeah. If it's absolutely obvious that you are not entitled, so with a grey area, yes, claim it. I'm not saying don't claim it. I'm just saying don't think that it's worth doing an absolute no-hoper, just in case it sneaks through.
But if it's one of these grey areas, then of course you're under a duty in effect to try and claim it.
Yes, absolutely.
Yeah, it'll be a bit tough for the revenue to try and impose a penalty.
But there was one quite recently where somebody put in a claim for business property relief on a Scottish hotel, Scottish holiday let.
Yeah. Oh, yes.
And I mean, I read that one and I thought, really and truly, it was pretty obvious that they were not going to get business property relief on that one. And, you know, I did think it was edging near to the position where just possibly the revenue might be saying you should never have claimed this. It was obvious that you weren't going to get it.
Yeah. Well, holiday homes are one. There is one case where it did succeed, isn't there, in recent years? But on the whole, no, holiday homes don't qualify for business property relief. For once they did, actually, but still.
Yeah, they've got to be like hotels.
Yes.
Right then, moving on. What does the future hold for lasting powers?
Well, there again, I don't really know. The Office of the Public Guardian is referring them at the moment. I think ultimately the aim of probably the government and the Office of Public Guardian is to get everything on the computer, online in effect, actually. But I think that's some time off, actually. But I think ultimately that's what you're going to have to do. Fill it in online. I don't know how they get around the signature. I think we'll all get a digital signature at some point. Apply to register it online as well, actually. Because if the computers work, then yes, it's going to save staff and things like that. Apart from the fact, I always think with computers, and I'm old enough to remember when they first came in and the unions objected. But I think they dropped their objections because they realised that computers were going to need far more staff, in effect. You know, people to maintain them and program them, and the original sort of way of doing it. No chap was unfortunately dead now. He was a bank manager. And he started in the 50s. He said, well, every day, the end of every day, they always used to tot up manually all the figures and all the interest that was due on overdrafts and things like that. Well, of course, that's all gone. The computer just does it. But someone's got to program the computer to do it and make sure it works, of course, actually. So I think that ultimately is the aim, that everything will become computerized. But I think that's probably some years off, actually. My own sort of personal graphs about lasting powers of attorney is I think the forms are far too complicated, actually. There's far too much information in them, I think, really. And I think if the idea is, I think that originally was the idea, that lay people should be able to do these things themselves without seeking professional assistance. But my experience is lots of lay people just look at all the documents on the Office of Public Guardian website about lasting powers of attorney and hold up their hands in horror and seek professional help, actually. So I think they do perhaps need to simplify them. I also think that there was a proposal that this should be done at one time, but they abandoned it, was you should combine the Property and Affairs and the Health and Welfare one into one document. And I thought that was a good idea on the whole, as long as they seriously simplified the documents. Because if you just stuck the two together, you're going to finish up with quite a complicated document. And most people, not everyone will, most people appoint the same people as attorneys under a Property and Affair and Health and Welfare one. And if I think we're different people, then obviously you'd have separate ones, actually. But I think they may well change the forms a bit, actually, and go a bit more towards computerizing everything. But I think we're probably 5 years off before we see the end of all this, actually.
I think it's not so much the forms. I think the forms have got noticeably better over the years. I think it's the guidance. I mean, you're absolutely right. If you tried to download everything, you would just disappear.
Well, I just think there's too much guidance in the actual forms. I always quite like the summary on the front, actually. I can't remember exactly what it says, but you know, to deal with your bank and building society accounts, to deal with your house. I think you just need succinct summaries because people read it. But if it's a page of text, are they all going to sit down and read it? Well, all right. Yes, I think they'd probably much rather watch EastEnders, wouldn't they, or something like that? But still, so. Right.
Okay, moving on. Do trustees pay higher rates if they are buying a dwelling for themselves, but hold a dwelling for the trust?
I think this is stamp duty land tax, I'm guessing. Yes. So no, trustees, if they own a dwelling within the trust as trustees, that's completely different from them owning a property themselves individually. I perhaps should say, for anybody who doesn't know, stamp duty, land tax, if you're buying a dwelling, trustees is, let's say I'm a trustee of my husband's will, and it might be for the benefit of our children. So I might buy a buy-to-let for the trust, and the issue is it's in my name. When I buy another property for myself, have I got two properties? The answer is no, because I'm owning one as a trustee and I'm owning one for myself. Having said that, somebody told me, and I don't know whether or not, well, I assume since they told me it is true, what I was told was that the revenue has people who are employed to go through the register at the land registry to pick up when properties are in somebody's name and they can see that that person already owns a property. And if the higher rate hasn't been paid, it's an extra 3%, they will send a letter saying, you appear to already have one property, you didn't pay the higher rate on this new property that you've just bought, can you explain why not? And of course, if you are a trustee, you'll be writing to say, well, either the original property I owned as a trustee, this is a purchase for myself individually, or the other way round. But although, your ownership as a trustee does not affect your personal ownership, it may lead to questions from the revenue as to how many properties you own.
Thank you very much. Unfortunately, unfortunately, that is all we have time for today. Thank you for attending Law 2021 online. Wills and Probate Shape the Debate, hosted by Inheritance Data. Thank you to our expert speakers, Professor Leslie King and John Thurston. Don't forget to join the solicitors group Law 2021 online community on LinkedIn to continue the debate after the live session and to be included in exclusive offers for future events. As I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within the next few days. There is still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. And there is still time to buy the complete event, including a recording of this live session if you haven't already. To book, just go to www.thesolicitorsgroup.co.uk, where you will also find the online exhibition. The exhibition is open to anyone to visit, and if you have booked the entire event, you can claim your free 1-hour CPD webinar from the webinar learning catalogue, worth £35 plus VAT. You can also visit our exhibitor profile for more information on inheritance data. Finally, feedback forms for the event will be sent out when the event closes. By completing this, you will receive your CPD certificate. Thank you again and have a great day.
Bye.
Right.
Bye.
Right then.